Hello, and welcome to my presentation for St. Petersburg College, the course of Legality and Ethics, ATE 3515. My name is Taylor Marquis, and today I will be presenting the legal case of Myers versus the City of Hartford, Connecticut. A little information and background on the case. This case was decided in court on August 10, 2004. The plaintiff in this case is Miss Eleanor Myers, who is the pet owner which this trial is based around. The defendants for this case include two individuals. The first is Edward Gradecki, the animal control officer in question for the City of Hartford, Connecticut. The second individual in this trial is Sandra Borges, the city manager for the City of Hartford, Connecticut at the time of this trial. The day in question. In April of 1999, Officer Gradecki received a complaint of a roaming dog. He arrived at the premises of the plaintiff, who was not home, to find a dog roaming in the yard. A nearby neighbor came outside to inform Officer Gradecki that the dog did in fact belong to the plaintiff. Officer Gradecki then waited approximately 5 minutes, according to the report, for the plaintiff to return home before removing the dog from the premises. According to Officer Gradecki, when he arrived, the dog was in such poor condition that he felt the only humane option was to euthanize. In making this determination, he in fact violated two laws in the state of Connecticut. He did not receive consent from the owner to euthanize, nor did he give an appropriate hold time for the owner to come forward and claim or give consent to euthanize. The owner was not informed before euthanasia. The second law that was violated in this case was that he also did not receive authorization for euthanasia from a licensed veterinarian, which was required under Statute 22-329A in the state of Connecticut before pursuing euthanasia of an animal. The plaintiff finds out several days later that her pet has in fact been euthanized. After finding out this information, she decides to take the City of Hartford, Connecticut to trial on the grounds of intentional and negligent infliction of emotional distress. She would like to file this claim under the statute 7-465. This case makes its way to court on January 24, 2003. The court ruled that the defendants were protected by qualified municipal immunity under General Statute 52-557 in A2. However, the plaintiff now appeals on grounds that her initial trial was unfair based on being tried under the incorrect statute. The appeal is granted, and the case is later taken to court again in August of 2004. A little explanation of the difference in statute in this case. Statute 52-557 in A2, which is a statute in which the case was originally filed in January of 2003, gives the employees of the state of Connecticut for the City of Hartford municipal immunity in cases such as this. However, when initially claimed, Ms. Myers claimed this lawsuit under statute 7-465, which would not allow immunity to municipal employees. Therefore, it was found that the claim that was initially to be taken to court was misfiled under the wrong statute. It was filed under statute 52-557 instead of 7-465, in which it should have been filed. The issues of the case. The 3 points that come into question are the following. Did the court improperly analyze Myers' claim under section 52-557 rather than under section 7-465? Do the actions of the defendants fall under the doctrine of qualified immunity? can Myers recover a claim resulting from the death of a pet? The judgment of the case. It was ruled that the plaintiff, Miss Eleanor Myers, could not lawfully recover claims of negligent infliction of emotional distress under Statute 7-465. The reasoning. The reasoning of the ruling in favor of the defendants is under Statute 22-350 in the state of Connecticut, animals are ruled as property. In the state of common law Connecticut, there is no common law authority that allows plaintiffs to recover non-economic damages resulting from a defendant's alleged negligent or intentional act resulting in the death of a pet. Miss Myers was unable to make claims towards this. Although the court evaluated the initial claim under the wrong statute, it was found that no harm resulted in the claim being misfiled due to the ruling being the same. In this particular case, there is no dissenting opinion, since the case was resolved August 10th of 2004. The final disposition of this case was that the case did in fact rule in favor of the defendants, being Officer Gradecki and Miss Borges for the city of Hartford, Connecticut. The plaintiff in this case, Miss Eleanor Myers, did not receive any form of compensation from the trial in result of emotional distress caused by the death of a pet. The case analysis. To me personally, this is a very complicated case. I personally do not agree with the ruling of the case. I do understand that under Statute 22-350 in the state of Connecticut that the plaintiff was unable to gain compensation from the trial. However, what I do not agree with is that the defendant, Officer Gradecki, that was in question during this trial did not appear to have been punished for unlawfully euthanizing an animal. From the statement that he had given, he claimed that the animal was in such poor condition that he felt euthanizing was the only humane option. However, as the neighbor stated and the initial report stated, whenever Officer Gradecki was originally called to the scene, the animal was up and around and moving. Roaming, which was the initial complaint. The officer in question did then take the animal to be euthanized. However, he did not attempt to hold the animal for an initial period to allow the owner to come forward. The owner was also not informed of the euthanasia and had to find out herself afterwards. So consent was not given from the owner to euthanize, nor was the owner previously informed of the euthanasia before it had happened. Also, with the second law that the officer in question, Officer Gradecki, has violated was that he did not get appropriate authorization to euthanize from a licensed veterinarian. And under Statute 22-329A, that is required in order to pursue euthanasia of an animal in the state of Connecticut. So therefore, I do not agree with the ruling based on the lack of punishment for the officer in question due to his actions. Because based on the laws in the state of Connecticut at this time, he did violate laws that should not give him immunity. I do understand the immunity in the case for the owner to not get compensation for emotional distress based on the death of the pet, but I do still believe that Officer Gradecki should face court charges based on his violation of the law under Statute 22-329A in the state of Connecticut, which implies that he was required to get authorization to euthanize from a licensed veterinarian before pursuing it further.